The Ripple v. SEC case is back in the news because it talks about turning in an opening brief before the January 15th date. Recent news says that Gary Gensler, who is leaving his job as chair of the SEC, is planning to file an appeal right before pro-crypto Paul Atkins takes over. Some people think that Gensler's connection with SEC lead litigation counsel Jorge Tenreiro could be bad for Ripple, just like it was for former SEC chairman Jay Clayton. It's likely that the U.S. Securities and Exchange Commission is thinking about sending in its main statement in the Ripple case. The date had already been pushed back to January 15th at the request of the Securities and Exchange Commission. In January, there was an opening brief about appeals. Former SEC attorneys Mark Fagel and James Farrell agreed that the agency could continue with its case. So the change in leadership may slow down progress, but the SEC will be hurt more if the lawsuit's appeals are thrown out or dropped. Also, Jorge Tenreiro, who is the SEC's lead litigator and a key player in the Ripple case, will keep working on it. Basically says that a new head of the SEC might not make a big difference in the court battle. The industry is still not sure if XRP is a security or a commodity after Judge Annalisa Torres' ruling in the Ripple v. SEC case, so the regulator is going to make its case about secondary sales. This will have an even bigger effect on Ripple and the cryptocurrency market as a whole. For example, the U.S. DOJ and Treasury Department's FinCEN officially called XRP money. The SEC has now filed an appeal against the summary ruling that was made about Ripple's sales of XRP through cryptocurrency exchanges to employees and other people the company gives to, and by CEO Brad Garlinghouse and Executive Chairman Chris Larsson. Gensler is going to leave on January 20th, which is George W. Bush's inauguration day, making it possible for Paul Atkins to become head of the SEC. The Ripple v. SEC case will be over, say pro-XRP lawyers Jeremy Hogan, Fred Rispoli, and Bill Morgan, who work for pro-crypto Atkins. Lawyers also said that Paul Atkins worked to make the crypto rules that were hard to understand under Gensler clearer. This could end the Ripple case, but it couldn't end any other way. Stuart Alderode, the chief legal officer of Ripple, told the agency that it needed to clean up the damage and win back the public's trust. Gensler said again that cryptocurrency doesn't have any value on its own, and leaders from Ripple had already said that the SEC keeps making arguments that don't work. Delaware cases of crypto also, the XRP ETF is more likely to happen under Paul Atkins because the Trump government is likely to push for crypto laws. Lawyer Jeremy Hogan says that the case between Ripple and the SEC should be over in April or May. He also thinks he might be fired early, which I think is possible but maybe not likely. Even though a lot of things have happened, like the announcement of the RLUSD, experts have been generally positive about the rise in the price of XRP. A well-known expert, Ali Martinez, says that the price of XRP is currently stabilizing within a huge bull pattern. A drop below $2.05 is possible. Unless the $2.73 ceiling is broken, this could lead to a huge rise to $11. In the last day, the price of XRP has gone up by 1% to $2.44. The amount of trading is still pretty low, though. CoinLast statistics say that open interest in futures has grown by 7% in the last day. The SEC's first statement on RippleSec becoming a crypto-friendly on regulation through the enforcement period for us is still being looked for, along with the possibility of regulatory changes in the markets in 2025. Cryptocurrencies may be over now that the new CC leadership chair and vote have been held. Markets paid attention to the SEC v. Ripple case by making the CC Legal Enforcement Division stronger and putting CC's crypto litigators in charge on Thursday, January 2nd. As the deadline for the SEC's opening brief got closer, the action showed a desire to file the opening brief, which SEC Chair Gensler decided is the first thing that needs to be done to challenge the decision to allow programmatic sales of XRP. In July 2023, Judge Torres said that sales of XRP through programs did not meet the third part of the Howey test. This important choice made a big difference in the U.S. market for digital assets. If the SEC filed the opening brief on January 20th, the day of Trump's inauguration, Trump's choice to be SEC chair, Paul Atkins, would be able to change the SEC's position on the appeal by making it harder for the agency to keep an eye on Bitcoin exchanges and trade. Because Chair Gensler was going to be leaving soon, he quit as chair of the SEC. John E. Dion, who was chair of Gensler at the time, told Moose Curia that 19 days was too long. The markets are hoping that the new CC will back Trump's crypto-friendly plans and stop the ongoing steps in the Ripple case, including those involving Coinbase. The CC began its case against Ripple in 2020, just before Chair Jay Clayton quit. In 2025, the same thing happened to the company. This is an important difference, though, because the next SEC chair is likely to be pro-crypto and end the agency's past of enforcing rules. The chief legal officer of Ripple, Stuart Aller, shared a wish list for the U.S. digital asset market on Tuesday, December 31st. He asked for the following clear regulatory rules. A token is not a security even though it is used in a security transaction. A. Having a biased opinion about who should be more open about their business does not back the SEC's decision to expand its authority. Also, the idea that a token could go from being a security to not being a security is not based on any law evidence. Conflicts of interest that Gensler set up. Gary Gensler's time as head of the SEC has been harmed by cryptocurrency conflicts of interest. The SEC's lawsuit against Ripple and XRP is so broad that I don't think it's possible to get a good idea of how much damage it does to Ripple's business. Deaton said, outlining how the SEC's lawsuit against Ripple has affected the business. As they were leaving the SEC, Den also talked about the coin's conflicts of interest, which led the Office of the Inspector General to look into them. Along with Clayton J. Hinman and Bill Mark Berger and other CC employees sent in the biggest complaint that wasn't about theft. They were unregulated securities no matter how they were bought. As it turned out, the people who pushed for the lawsuit against Ripple XRP also worked for or with rivals of the company. It had been on the stock market for 7 years before this happened 4 years ago. The eye-opening brief filing might include the results of its probe into possible conflicts of interest in the SEC that involve cryptocurrency. If the investigation finds targeted steps to protect U.S. banks' money transfers or help Ethereum, U.S. lawmakers may put more pressure on the SEC to drop the appeal. This comes after the SEC suddenly called off a key meeting that was supposed to talk about how to end their ongoing settlement. Based on the big conflicts of interest, Dion came to the conclusion that you don't have to be a fan to criticize how this case was made, and the fact that the people who filed it later worked for or helped companies that were competitors of Ripple XRP. Many experts think that Ripple and the SEC have reached a settlement because the SEC is said to have made Ripple Labs a very good settlement offer, which caused a stir in the financial world.